Hello, my name is Professor Shladitya Rakshit, Module 4, Environment 1, Learning Outcomes. To give students an overview of the role played by the various courts in the protection of environment and human rights, by the end of the module, students will have an understanding of the role of public interest litigation in the developing of environment jurisprudence in India. Introduction. Environmental protection and human rights. The public interest litigation province has become very wide. Under Article 32, the Supreme Court has expanded the prospects and interfered whenever injustice is caused or being caused by state action or by lack of it. It has tried to help the poor, hopeless and helpless people who have no means to approach the Supreme Court or who don't know whom to approach. Public interest litigation has today become an axiom for judicial involvement in social, political and economic affairs of the Indian society and the state. The province of public interest litigation has extended so much that every inquiry to every grievance can be brought under it. The protection and improvement of human environments, one of the major areas of concern for PIL. A clean and healthy environment is a fundamental need of the existence of life. The ecological imbalance contributes to the environmental hazards like acid rains, noise pollution, air pollution, water pollution. The depletion of ozone layer causes skin cancer, cataracts, damage to the body's immunity systems, mutation, loss of productivity. Environmental law is an instrument to protect and improve the environment and to control or prevent any acts or omissions likely to pollute the environment. Therefore, there are hundreds of environmental laws in India, directly or indirectly dealing with the subject of environment. Constitutional and legal provisions dealing with protection of environment. The Stockholm Declaration of 1972 was one of the major attempts to conserve and protect the human environment at the international level. As a result of this declaration, the states were required to adopt legislative measures to protect and improve the environment. Accordingly, Indian Parliament inserted two articles, that is 48A and 51A in the Constitution of India in 1976. Article 48A of the Constitution directs that the state shall endeavour to protect and improve the environment and safeguard forests and wildlife of the countries. Similarly, Clause G of Article 51A imposes a duty on every citizen of India to protect and improve the natural environment, including forests, lakes, river and wildlife, and to have compassion for living creatures. The collective effect of Articles 48A and 51A Clause G imply that the state as well as the citizens both are now under constitutional obligations to conserve, preserve, protect and improve the environment. Every generation owes a duty to all succeeding generations to develop and conserve the natural resources of the nation in the best possible way. It is to be noted that these provisions, though not enforceable in court of law, direct the states to enact legislations and frame policies towards the promotion and protection of environment. Thus, the state is under a moral duty to take measures to prevent ecological imbalances resulting from modern industrialization. The Constitution has also cast a duty on the citizen to take steps for maintaining ecological balance. Besides these, Sections 227 and 278 of the Indian Penal Code and Sections 133 and 134 of the Code of Criminal Procedure are some other provisions which contain mandate to protect and improve the environment. Legislations dealing with the protection of environment. In addition to the constitutional mandate to protect and improve the environment, there are plenty of legislation on the subject. Some of the relevant legislations are: number 1, the Water within brackets Prevention and Control of Pollution close brackets Act 1974. 2, the Water open brackets Prevention and Control of Pollution close brackets Cess Act 1977. 3, the Air Prevention and Control of Pollution Act 1981, the Environment Protection Act 1986, Public Liability Insurance Act 1991, the National Environment Tribunal Act 1995, and the National Environment Appellate Authority Act 1997, and the Wildlife Protection Act of 1972, the Forest Conservation Act of 1980. Judicial contributions to the protection of environment. The apex judiciary in India has been indicating its commitment for the protection of environment from time to time, and it has given prime importance to the environmental promotion and protection through various judgments. The expansive and creative judicial interpretation of the word life in Article 21 has led to the constructive development of environmental jurisprudence in India. The right to life is a fundamental right under Article 21, and since the right to life connotes quality of life, a person has a right to the enjoyment of pollution-free water and air to enjoy life fully. The judiciary has recognized right to a clean and wholesome environment and the right to clean air and water under Article 21 of the Constitution. The fundamental right to life and personal liberty has become a sanctuary of human values for more environmental protection. The Supreme Court has played a key role in filling the gap between the legislation and its implementation by constructive interpretation of environment law. Most of the actions in the environmental cases are brought under Articles 32 and 226 of the Constitution. The environmental litigations are generally based on the notions of violation of fundamental rights. It is to be noted that the higher judiciary has always endeavored to strike a balance between conservation of environment on one hand and the economic development on the other hand. Due to this reason, the judiciary has given guidelines to safeguard the society against the ill effects of industrialization. Extension of scope of locus standi in environment cases. The traditional rule of locus standi states a person whose right is infringed alone can file a petition. In Ratlam Municipality versus Vardhichand, the Supreme Court explained the principle of locus standi in environmental cases and observed that environment-related issues must be considered in a different perspective. In this case, the court directed the Ratlam municipality to provide sanitation and drainage despite the budgetary constraints, thereby enabling the poor to live with dignity. This development in judicial delivery systems is considered as a silent legal revolution. It has hurled constraints posed by the technical rules of procedure and paved a path for litigation from public-spirited persons. The court not only complimented petitioners who filed environment protection litigation, but also awarded money to the petitioners. Right of the people to live in healthy environment. The Indian Constitution is one of the unique constitutions of the world. In India, the concern for environment protection has not only been raised to the status of fundamental law of the land, but it is also wedded with the human rights of every individual to live in pollution-free environment with full human dignity. The Constitution of India obligates the state as well as citizens to protect and improve the environment. The Supreme Court gave an expansive meaning to right to environment in rural litigation and entitlement Kendra, Dehradun versus State of UP. The representatives of the rural litigation and entitlement Kendra, Dehradun, wrote a letter to the Supreme Court alleging that illegal limestone quarries in the Mussoorie-Dehradun region was devastating the fragile ecosystem in the area. The court treated the letter as a writ petition under Article 32 of the Constitution. In the instant case, the court presupposes the violation of fundamental right. The court ordered the closure of certain limestone quarries on the ground as there were some serious deficiencies regarding safety and hazards in them. The court stated the right of the people to live in healthy environment with minimum disturbance of ecological balance and without avoidable hazard to them and to their cattle, house and agriculture, land and pollution of air, water and environment. In Govind Singh versus Shanti Swarup, the Supreme Court has taken microscopic view on the contours of the law of public nuisance. In the instant case, the Supreme Court held that the effect of running bakery was injurious to the people as it was polluting the environment by emitting smoke from chimney and ordered the closure of the bakery. The court said that in a matter of the nature, what is involved is not merely the right of a private individual, but the health, safety and convenience of the public at large. T.N. Godavarman, Thirumalpad versus Union of India, the Supreme Court imposed a fine of ₹1 crore on the government of Himachal Pradesh for neglecting the ecology by allowing companies to paint advertisements on eco-fragile rock faces on both sides of the Rohtang-Manali road. The court said that the amount would be a part of ₹5 crore corpus to be created from the money to be levied on the delinquent companies. The court directed to use the money for restoring the ecology disturbed by the painting of advertisements on the rock faces done by MBD Books, Coca-Cola, Pepsi and Birla Whites. Right to health and medical care. In Consumer Education and Research Centre versus Union of India, the Supreme Court has delivered a historic judgment and held that the right to health and medical care is a fundamental right under Article 21 of the Constitution, as it is essential for making the life of the workman meaningful and purposeful with dignity of persons. Right to access to drinking water. It is pertinent to mention that the right to access to drinking water is fundamental to life, and there is a duty on the state under Article 21 to provide clean drinking water to its citizens. In APPCB versus MV Naidu, the court ruled drinking water is of primary importance in any country. In fact, India is a party to resolution of the UNO passed during the United Nations Water Conference in 1977, as all people, whatever their stage of development and their social economic conditions, have the right to have access to drinking water in quantum and of quality equal to their basic needs. The court observed water is the basic need for the survival of human beings and is a part of the right to life and human rights as enshrined in Article 21 of the Constitution of India. Water pollution. In M.C. Mehta versus Union of India, which is known as Ganga water pollution case, the Supreme Court considered the problem of pollution of Ganga water by the effluent discharged from the tanneries. The Supreme Court directed the owners of the tanneries to establish the primary treatment plants so as to prevent the pollution of the Ganga water being used by a large number of people of the country. The polluted water affects the health and life of the people. The court observed that the financial capacity of the tanneries should be considered as irrelevant while requiring them to establish the treatment plants. At last, it has resulted in the closure of tanneries which were polluting the holy river Ganga. In Mukti Sangharsha movement versus State of Maharashtra sought to prevent reckless exploitation of river running through some parts of Maharashtra which was adversely affecting the bed due to reckless quarrying of its sand. In F. K. Hussain versus Union of India sought to prevent lowering of underground water level on account of its reckless withdrawal by electric pumps. This case was also referred by Kerala High Court. In this point to be noted that the right to sweet water and the right to free air are attributes of the right to life, for those are basic elements which sustain life itself. In Goa Foundations versus the Konkan Railway Corporation, in this case the Bombay High Court held that development was not possible without some adverse effect on the environment and ecology. The project of public utility cannot be abandoned if there are some adverse effects. Therefore, it is equally important to adjust the interest of the people and to maintain the environment. Development is necessary because without it there will not be any progress, but must also be in close harmony with the environment. If the development is intended to achieve without taking into consideration the environment and the ecosystem, there will be total devastation. The Taj Mahal Case. The writ petition filed by M.C. Mehta versus Union of India was popularly known as the Taj Mahal Case. In this case, the sulfur dioxide emitted by the Mathura refineries and industries was causing atmospheric pollution, due to which Taj Mahal, a monument of international fame and repute, was being affected. It was therefore contended by the petitioner that preventive steps should be taken to save the degradations of Taj Mahal. The Supreme Court observed that the Taj Mahal is the cultural heritage of India and it is also a source of revenue for the country as millions of tourists visit it every year. The court adopted the path of sustainable development. The court issued directions that coal and coke-based industries in Taj Trapezium Zone, the TTZ, which were damaging Taj, should either change over to natural gas or to be relocated outside TTZ to the alternate site provided under Agra Master Plan. The Supreme Court also directed to protect the plants planted around Taj as mentioned under the Divisional Forest Officer Agra is directed to take immediate steps for seeing that water is supplied to the plants. The Union government is directed to release the funds immediately without waiting for receipt of the proposal from the UP government on the basis of the copy of the report. Funding may be subsequently settled with the UP government, but in any set of circumstances for want of funds, the officer is directed to see that plants do not wither away. Silent Valley Case. In Kerala, the Kerala Sastra Sahitya Parishad KSSP led the campaign against the Silent Valley project. The PIL was filed against the government to stop the execution of the project. The purpose of filing this PIL was to pressure and exert influence on the government to initiate the development project after making proper environment impact assessment. The Silent Valley movement in Kerala is an example of people's response to ecological problem and to work as a pressure group in the field of environment protection. The freedom of speech and expression by the Kerala Shastra Sahitya Parishad, which is the non-governmental organization, coupled with the help of the influential environmentalists within and outside the government and the powerful assistance of media, compelled the government to abandon the Silent Valley project. The Coastal Protection Case. It is also known as H-acid case of Bichri village case. The environment organization, the Indian Council for Enviro Legal Action, filed a PIL before the Supreme Court against some chemical industries producing certain hazardous chemicals in an industrial complex at village Bichri in Udaipur state of Rajasthan. The industries had not obtained the necessary license, clearance or consent from the statutory authorities. They had not installed any equipment for the treatment of highly toxic waste materials and discharged from such industries. The highly toxic effluents were sufficient enough to poison the earth, the water and everything that came in contact with the same. The writ petition was filed complaining the above situation. The Supreme Court requested NEDI, that is National Environment Engineering Institute, to study the situation pertaining to the effects and consequence of these chemical industries situated at Bichri village and put up their report. The report of NEDI revealed that the respondent did not carry out the order of the Supreme Court fully in the matter of removal of sludge, and the respondent did not fulfill the undertaking given by them to the court. The respondent, without respecting the reports officials and expert body, continued their illegal course of action leading to contempt for law. The Supreme Court held that the respondent were responsible for all the damage to the soil, to the underground water and to the village. The court's engagement with these matters has resulted in activating the statutory machinery established under various environmental laws. The court's activism in this area has, however, also attracted criticism. For instance, when the court ordered the closure of industries, in neither heard all the industries affected nor their workmen before passing the order. This has resulted in these parties approaching the court with a series of interlocutory applications, taking up an inordinate amount of court's time even while leaving the aggrieved parties dissatisfied. The Dehradun Valley case. In that case, carrying hazardous and dangerous limestone quarrying in the Mussoorie Hill range of the Himalayas, mines blasting out the hills with dynamite, extracting limestone from thousands of acres, had upset the hydrological system of the valley. The Supreme Court ordered the closing of limestone quarrying in the hills and observed that this would undoubtedly cause hardship to them, but it's a price that has to be paid for protecting and safeguarding the right of the people to live in healthy environment with minimal disturbance of ecological balance. Smoking in public places. In 2001, the Supreme Court of India imposed ban on smoking of tobacco in public places all over the country. Smoking causes harm not only to smokers but also to non-smokers who are forced to inhale the second-hand smoke. More than 3 million people die every year in India as a result of smoking tobacco, including bidis and cigarettes. 1 lakh Indians get lung cancer every year because of smoking. Indeed, lung cancer kills 95% of its victims. That is why the apex court ruling has immense social value. But no one cares for the ban. As you know, the cigarettes and bidis are openly sold in tobacco-free railway stations, bus stands, cinema houses, etc. The statutory warning, smoking is injurious to health, is printed in such small prints and color that hardly it is readable. That is the irony of it. Even if it is readable, it has not served any purpose. So it is the social awakening which can only help us to prevent smoking. Pollution in Delhi. In Al-Mitra H. Patil versus Union of India, the Supreme Court reiterated the observations made in that Delhi is one of the most polluted cities to residents of Delhi. The ambient air is so much polluted that it is difficult to breathe. More and more Delhiites are suffering from respiratory diseases and throat infections. River Yamuna, the main source of drinking water supply, is the free dumping place for untreated sewerage and industrial waste. Apart from air and water pollution, the city is virtually an open dustbin. Garbage strewn all over Delhi is a common sight. The court directed the authorities to take immediate necessary steps to control pollution and protect the environment. The Shriram Food and Fertilizer Case, the oleum leak case. In that case, a major leakage of oleum gas affected a large number of persons, both amongst the workmen and the public. The Supreme Court held that where enterprise is engaged in a hazardous or inherently dangerous activity and harm results to anyone on account of an accident in the operation of such hazardous and inherently dangerous activity resulting in the escape of toxic gas, the enterprise is strictly and absolutely liable to compensate all those who are affected by the accident, and such a liability is not subject to any exceptions in the world. Public health. The Supreme Court has emphasized the importance of preservation of public health. In Subbarao versus State of Himachal Pradesh, the Supreme Court ordered the closure of a bone factory which was polluting the environment by its pungent smell and making the life of the people miserable. No one can do business at the cost of public health. In Municipal Council Ratlam versus Vardichand and others, the Supreme Court held that the grievous failure of local authorities to provide the basic amenity of public conveniences drives the miserable slum dwellers to ease in the streets on the sly for a time and openly thereafter, because under nature's pressure, bashfulness becomes a luxury and dignity a difficult art. Responsible municipal council constituted for the purpose of preserving public health care run away from its duty by pleading financial inability. Public park. A place which is reserved for public park cannot be converted for use into a private nursing home. In Bangalore Medical Trust versus B.S. Mudappa, the Supreme Court set aside the decision of the Bangalore Development Authority granting permission for converting the place reserved for public park for the establishment of a nursing home and observed thus: the public interest on reservation and preservation of open spaces for parks and playgrounds cannot be sacrificed by leasing or selling such sites to private persons for conversion to some other use. The Bhopal Gas Case. The Bhopal Gas Case leak was one of the most tragic industrial disasters of the past few centuries. On December 3, 1984, just after midnight, 40 tons of highly toxic methane isocyanate MIC, which has been manufactured and stored in Union Carbide's chemical plant in Bhopal, escaped into the atmosphere and killed over 3,500 people, and as many as 2 lakhs others were injured, many seriously, some permanently. In April 1985, for early and effective settlement of claims arising out of disaster, the Bhopal Gas Leak Disaster Processing of Claims Act was enacted, which conferred an exclusive right to the Indian government to represent all claimants both within and outside India, and directed the government to organize a plan for the registration and processing of victims' claims. Then the Indian government sued Union Carbide in the US. The US court declined to try suit on the ground that Indian courts were the appropriate forum. Consequently, in September 1986, the Indian government sued Union Carbide in the court of the District Judge Bhopal for Rs 3,900 crores on the basis of more than a prima facie case having been made out against Union Carbide. Then Union Carbide claimed the Supreme Court judgment was unsustainable because it amounted to a verdict without trial. The Indian government also appealed before the Supreme Court because the High Court had reduced interim payment award to Rs 350 crores granted by District Judge Bhopal by 30%. The Supreme Court secured a compromise between the Union Carbide Corporation UCC and the Government of India. Under the settlement of UCC agreed to pay US $470 million in full and final settlement of all past, present and future claims arising out of Bhopal disaster. In addition, to facilitate the settlement, the Supreme Court exercised its extraordinary jurisdiction and terminated all the civil, criminal and contempt of court proceedings that had arisen out of the Bhopal disaster. The Supreme Court, in its order of 4th May 1989, set forth the reasons for urging the settlement. The court stated that in view of the enormity of human suffering provocation by the Bhopal gas disaster, there was a pressing urgency to provide immediate and sustainable relief to the victims. In December 1989, the Supreme Court in the Charan Lal Sahu case upheld the constitutionality of the Bhopal Gas Leak Disaster Processing of Claims Act 1985. Under the said Act, the Indian government reserved for itself the exclusive right to represent all Bhopal victims in civil litigations against Union Carbide Corporation. In this case, the Supreme Court declared that to do a greater right, it is permissible to do a little wrong. Regarding this case, noted academic Upendra Bakshi has observed that the Bhopal gas leak involved two disasters, one being the huge loss of life and secondly the absence of a clear legal framework to bring relief to those affected by the same. Summary: in this module, we looked into the constitutional and legal provisions dealing with the protection of the environment. We also looked into legislations dealing with the protection of the environment, the judicial contribution to the protection of environment, and the right of people to a safe and clean environment with reference to respective case laws. Thank you.